Hello, everybody. I had to reboot my computer. Hello, boss lady. When I was in the big city with my daughter, I turned on my camera remotely to just check the room, keep an eye on things. And yeah, somehow it got stuck and it wouldn't register that I had closed my camera, so it wouldn't let me start up StreamYard. But yeah, in the big city, I decided to get myself a doorbell cam. I went with Eufy because it is the only one that does not require a monthly subscription. They are kind of, I don't want to say new at Best Buy, but they're one of the newer companies, and they've been really working well for them. So I am charging it because I don't have a wired doorbell. So I'm charging it right now, and it's going to give me about a month in the summertime and a couple of months during the wintertime of secure access and constant ability to talk to whoever's at my door without having to, hey, you stop it or I'm going to put a camera right on you. Yeah, so I can answer my door without answering my door. And yeah, and that way I can see when stop it. Hey, Bandit. You are just too cute. And you know it. Just because you move slower doesn't mean I don't know exactly what you're doing. Oh, right at the heartstrings, guys. Right at the heartstrings. Stop it. Come over here. So, but yeah, so I figure if he ever brings that classless trash hoe back to my house, I'll see. Oh, she knows the treats are over here, but in front of the treats is, a roll of tissue paper and my pill bottle and cortisone cream and, other random little items. And so she's like grabbing the top of my pill bottle with her paw and flipping it off. I came in the room the other day and I have a stack of like old insurance cards and old credit cards that are like expired and stuff like that I need to throw through the shredder the next time that I do a shred. I just shred all my stuff all at one time. So the next time that I have a little shred party, they need to go through it. And I came in and all of the cards were all over the floor. Like she individually picked everyone off of the desk or something. Stop it. Hey, you have had enough treats for the day, Missy. Ha. I love her. I love her so much. So, hello, Nana Laura. Speaking of people that I love. Hello, C-Rex, my sweet. Sleep well. Oh, don't you even. Hey, stop it. You have to be nice, Bandit. I'm going to put that bully solution on you. Jackson Galaxy's bully solution. It doesn't seem to calm her any, though. Oh, probably because it just runs right off your butt. I got some on her neck, though. So it's like 5 drops, but it all just flows right off of her because she's so plush. She's like water resistant. Oh, wow. It's already a circus here. Hello, Lisette Panette. Hello, Micah Psycho 1. I love you so much. Hello, Eileenie Carlin. I got your mug out. You should have it Saturday. Hello, Spider-Man. Yes. Yes, yes, and yes. And a resounding yes. Absolutely. That's exactly what it is. That is exactly what she does. Yep. She's like, I want those treats. So everything. Well, and the thing is, though, when the treats are here and completely accessible with nothing else around them, she goes to the other end of the desk and just starts rummaging through things to knock stuff over. I think she's just. Well, I know. But you don't realize how many treats she gets in a day. Every time she gives me kisses, I give her treats. And so she gives lots of kisses. Oh, yeah. These ones are Frisky's Party Mix. And they come in like little stars and fishies and stuff like that. And then there's a box of Temptations that I put into the last Frisky's Party Mix container, just because this one is more secure than the Temptations one that the lid can pop off of. So yeah, they get plenty of treats. Hello, Mark. Good to see you, honey. So we've got Judge Belargin tonight, and we have Judge Satterfield absolutely losing her mind and regretting her past decisions. And then we have Eric Martin. And y'all wanted him. Old Squishy Gardner, unprompted, reached out to me. And he sent me the case that he had already edited and put up on his channel for me to be able to use without having to do the extra work. I can't tell you how grateful I am for that. Editing is a lot of work. So for him to just graciously give me something that he's already put time and effort into, I am honored. I truly am honored to have such wonderful people in my life. He did tell me that there was a motions hearing today, but I took my kid to the big city and I wasn't home. And I set up all of the dockets to download, and unfortunately, Judge Satterfield or Judge Shackelford did not download. So, or if she did, the file was corrupt and unreadable. I don't know which it is because both happen. So, all I know is I don't have today's motions hearing. But yeah, he truly is. Oh! Oh, well then I do have it. Hmm. Well, I heard the judge talking about that at the beginning of this one. Okay. I can, I'm, mm. Have you already got it posted? I cannot believe how generous you are. Thank you so much. I was worried that I wouldn't have enough for you all tonight. And then he came through and helped me. Oh, you're awesome. All right. So before we play Eric Martin, hey, the tail says it all. The tail says it all. You think she cares? Um, so when we get that far, when we get to Eric Martin, we'll pop on over to OSG's channel and we'll watch it on there, and then we'll pop back over here and watch it. Oh my gosh. Thank you so much. Dana M. Honey. Hi. Um, I'm working on a new t-shirt. Um with the word of the day from yesterday. Or the other day, whatever day it was. I can't even remember, but it was so great. So great. I really have the best subscribers in all of YouTube Landia. I really do. They are all so great, and you're one of them. So you're amazing. Alrighty. Yes, 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 yes. It's funny because I want a specific type of font that doesn't exactly exist. So I thought, oh, I'll just have AI help me with the font. Um, and they made like 15 different variations of it. And I kind of liked them. I liked some of them, but parts of others. And I was just getting frustrated because I couldn't get exactly how I wanted. And I was like, okay, I'm going to take a break from this and I'll come back to it. Right. So when I came back to it, it refused to write it for me. And then it admonished me. It was telling me that using that phrase, it could get me in trouble with Google guidelines and permissions, and it could demonetize me if people got angry about it. And I'm like, it's not the word you think it is. And then they because I'm talking to Gemini, right? I'm talking to Google itself. And I said I didn't use this word. I used this word. And they said, my apologies for misunderstanding you. You are correct that it is a different word. However, it is so close to the derogatory word, and pairing it with these other words, we just cannot condone that behavior. I'm like, Google's yelling at me. I've never been yelled at by a computer before. It's almost like dating Jay Regier. No kidding. Oh my gosh. Oh, you wait till they start chipping us all. Oh, Mortimer Duke was talking to me on Discord earlier, and he was asking me all sorts of questions about the house and everything like that. And the end conclusion was, he said, what would Jay Regier do? And I said he would cry sad robot tears with an oil rag. Hello, Charlie. I love you. Oh my goodness. Yeah. I love this life, you guys. I do. I love this life so much. I just have to figure out how to make that font and have it say what I want it to say. And I'm not good at that part. And unfortunately, my phrasing is not nice enough for Google. Oh, he knows. He knows. Are you kidding? I'm sure he's tagged in so much stuff. I bet 80% of it is an act. Well, I mean, there was that running theory on the channel for a while that, that he owns his own swinger shop. He really does seem like the kind of guy that might have a dom. What are you doing? There is no under the bed. You can't get under there. It's a box bringing 2 mattresses. What are you doing, doof? I did not try that one, but I mean, it wouldn't fit the it wouldn't work. Just saying. You just wait. You're gonna be so impressed with it. You're gonna be so impressed with it. And then you'll get one. You're gonna have one. It's on me. You're gonna get one. All right, guys. Let's get into this. Let's have some fun. Oh, why did I do that? I didn't do that. I did not mean to do that. I hate the update that if I click that button, I end up immediately going to the corner, whether there's something on screen or not. That's why he needed the oil rag. Oh my gosh, you guys, you're gonna kill me. You really are. I'm just as not. I can't. You're scaring Ava. Oh my.
Let's go on the record in the matter of People's State of Michigan versus Akey, file 251946FY. My understanding, this is going to be a plea and sentence, so someone explain to me what we are going to do then.
Yes,
Let's have
Your Honor, good
appearances
afternoon.
first.
This is Adam Townsend and Abigail Cote on behalf of Mr. Akey, who's seated here to my right. Your Honor, we reached an plea agreement with the prosecutor's office in which Mr. Akey will plead to an assault and part of the domestic violence, which is count 2 of the felony complaint. We understand and have an agreement that will involve diversion and deferral of the conviction with no upfront jail time, and also a dismissal of the felony child abuse count, which is count 1 of the felony complaint. That's the defense's understanding, Your Honor.
Mr. Duffield, so it's going to be a plea to count 2, dismissing count 1?
That is correct, with the hope that the defendant would be accepted into the domestic violence diversion program.
Mr. Duffield, do you have victim notice?
Apologies, Your Honor. Yes, I believe we do.
Well, the reason I ask is because they have a right to be here for sentencing if they choose to be. So we can proceed and take the plea and set it for sentencing, or we can proceed to sentencing if indeed there's already been victim notice and they have.
Yes,
are
Your Honor,
agreeable to-
according to my notes, I'm sorry, we have contacted the victim and I don't believe we've heard a response, so we are sufficient to proceed to sentencing as well as taking the plea today.
All right. Mr. Akey, you heard what your attorney stated and what the prosecuting attorney has confirmed.
Yes, Your Honor.
You understand, sir, that you have a right to proceed to trial, and if you did proceed to trial, the prosecution would be obligated to prove that you're guilty of the charges brought against you beyond a reasonable doubt. You understand that?
I do, Your Honor.
You understand further that if you make this plea here today, you're going to tell us you are in fact guilty of domestic violence. People will dismiss the felony charge of child abuse, and that's how the matter is going to be resolved. There will be no trial of any kind. Is that your understanding, and is that your intention?
Yes, Your Honor. That is my understanding.
Has
My
anyone tried to frighten you? I'm sorry, go ahead. Say that again if you would, please. I didn't mean to cut you off.
No, that was my understanding, my intention, Your Honor. So, yes.
Has anyone tried to frighten you or force you or intimidate you into doing this?
No.
Has anyone made any promises to you that have not been placed on the record here today?
No, Your Honor.
Are you currently on probation or parole for any other criminal convictions?
No, Your Honor.
The allegation indicates that this is an incident that occurred between January 1st, 2023 and March 23rd, 2025. Does that sound right to you?
Yes, Your Honor.
The allegation is that this incident took place in Ganges Township of Allegan County in the state of Michigan. Does that sound correct to you?
Yes, Your Honor.
The allegation is you made an assault or assault and battery upon Maxwell Akey, resident or former resident of your household. Is that true?
Yes, Your Honor.
Who is Maxwell Akey?
He is my son.
And how old is Maxwell Akey?
He is 9 today, Your Honor.
Happy birthday to your son. You feel like a big man having a temper tantrum in front of your 8-year-old child? 9 today? Slamming doors and scaring the hell out of him? Make you feel big?
And what did you do that constituted the assault and or assault and battery?
Your Honor, may I ask my client questions to establish the factual basis if the court would so allow?
Well, sure.
So, Mr. Akey, you acknowledge that between January of 2023 and March of 2025, there were incidents where you lost control of your emotions. You had emotional outbursts and lost control of your anger.
Yes.
And on certain of those occasions, Mr. Akey, did you also engage in physical conduct like slamming doors and engaging in other sort of aggressive conduct?
Yes, Mr. Townsend.
And Mr. Akey, did you understand Maxwell was there, and you understand that your actions during this time period placed Max in fear of an immediate contact that was unconsented?
Yes, sir.
Okay. And again, was Max a member of your household during this time period?
Yes, sir.
Okay, Your Honor, again, I think that's a sufficient factual basis for the assault as charged in count 2 of the felony complaint, unless the court has any additional questions.
Was there physical contact in these exchanges?
No, Your Honor.
Now is a good time to just come forward with things because we are, whether or not we put this matter into diversion, it's an important aspect that I feel as though that we have someone who's taking full responsibility for their actions.
Absolutely.
I understand that things happen, and that's why we utilize diversion to help people provide them with counseling, anger management aspects and such to prevent such things from happening again. But there's a little bit of a caveat with diversion, please. Let me explain though, just so we make sure that we're not just ships crossing, missing each other in the dark, so to speak, or in the
Yes,
fog. Diversion requires accepting guilt and taking responsibility and really owning it. And then we can deal with it with the counseling and such. And then hopefully I have every reason to believe you would be fully successful if we did utilize diversion. Not saying I'm going to do that yet, but if we were to do that, the exchange on that would be, this would be removed from your public record. So, but if there's not owning the situation, it's hard to get to that point where we are able to work with it. Do you see where I'm going?
Oh, absolutely. I am owning to this and absolutely am looking forward, as my family is too, and into me working through this diversion program in rehabilitation and making sure that these things never occur again, and that I have a, loving, working, functional, that Max has the best atmosphere at his home that we can provide, and that I absolutely, this is what I would like and what my wife would like to see with me as well. And I absolutely feel horrible, absolutely horrible. I haven't been able to sleep at all. And this has just been, I can't tell you how awful an experience. And I'm so sorry I absolutely own up to any of that Max may have felt.
Okay, before we go much further down the road here, and I get the idea that you have a sense of contrition and such, but owning actual actions and the idea, there's a little bit of a separation here. And the reason I'm pushing back on this, sir, is because I'm kind of looking at the affidavit for the warrant to begin with. And I don't know if you had a chance to review that with your attorney. And if you want, I'll let you do that, and we can come back to finish up with this if you haven't done that. But there's some rather specific allegations in there that, at least to my mind, are, something that I think it's worth it for us to invest in, saying, okay, here, this is what happened. It's wrong. I own it, and we're going to go into this diversion program, and and we move forward. But of all the times to own something, now is the time, because you have a path forward here. So
And Your Honor,
I don't know, you want to, if you'd like a breakout room, I'd let you do that. I don't want you to discuss it in open court in front of me and such, because I certainly don't want to deprive you of, and I certainly don't want to put words in your mouth either. But the thing is, I'm really wanting to have this to be, if we utilize diversion, I want it to be effective.
yes, and Your Honor, let me step in here on behalf of my client. And we've had the opportunity to review the affidavit. We've had the opportunity to discuss both the alleged incidents in that affidavit and the discovery that we received from the prosecutor's office about those. Just so I'm clear with the court, I recommended, my client is not prepared to say that either of those incidents happened. And I personally feel like the defense has good arguments about those. I think what we're saying, Your Honor, is that notwithstanding what's alleged in the affidavit, that my client has engaged in a course of intentional conduct, both verbally and while not involving physical contact to the child, these loss of control episodes with the slamming of doors and the nature of the outbursts, my client knew put his son in reasonable apprehension of immediate contact. I will also say, Your Honor, that defense's understanding is that the misdemeanor plea here would be, for the assault, based on my conversations with the prosecutor's office even this morning, would be eligible for diversion. And so if there's any misapprehension, if there's any crossed wires here, I take full responsibility for that. But I wanted the court to have the benefit of that insight as we're going through.
No. I'm not saying he's not eligible for diversion. I'm just saying whether I'm willing to put him on diversion. That's my concern, because to me, putting someone on diversion, means that, we have fairly strong confidence that they're going to own the situation, and then by owning it, we're going to be able to work on it rather than just tiptoe around the shadows. And, understand, I mean, it's absolutely eligible, but there's no promises in regard to my sentencing is on anything. Recommendations of the prosecutor are very much welcome and accepted, as are recommendations of defense counsel and even statements the defendants make on their plea. But once we go beyond that, I take that into consideration, then I pronounce sentencing. So again, I am not trying to put words in anyone's mouth. I'm trying to make sure that we have the most successful possible diversion program. If you want a moment to talk about it, that's great. If you don't, we can just proceed, and I will inquire of Mr. Duffield and proceed from there.
Yes, maybe just have a brief moment with my client then, Your Honor.
Before I run Ava out real quick, I just need to say that I absolutely love Judge Belargin for this. 100% love him. Because Mr. Akey right now is terrified that he might not get the diversion program. Absolutely terrified. And you know what? The judge doesn't have to slam doors or scream to put him that way.
Give him a breakout room then. Or actually, we can just, if you just mute yourself, we won't hear you, so that's fine.
Honor, if you can hear me though, please advise. But I am going to mute the mic.
Yeah, we can hear you. So if you want to mute yourself, that'd be better. All right, let's go, Mr. Thompson. You and your client, I think you indicated you were ready. So let's go back on the record with that matter.
Thank you, Your Honor. Yes, my client does have some additional statements he would like to make to the court. I think my concern as his counsel is, if the court is not satisfied, I think my preference would be to take a break and to adjourn this to do some more work if we need to. And I know the court can't tell me in advance what its ruling is going to be without having heard from my client, but I want to make sure that I'm effectively representing his interests. And I think with what's at stake, I'm concerned based on the colloquy to this point.
You're concerned based on what?
I'm concerned based on the court's reaction thus far to on the acceptance of responsibility. And so my advice to my client is that we may want to consider adjourning this to do some more work. He has other things he would like to inform the court, but the stakes are high for him. I want to make sure that that he's being intentional and that everything is being done appropriately. So that's where we are. He's happy to make an additional statement to the court, though, that I think may assuage some of the court's concerns.
Yes, Your Honor.
Well, if he's willing, I'm not asking. I don't want to put words in anyone's mouth. If he wants to make an additional statement, that's fine, and we're able to proceed. We take care of these matters all the time. I mean,
Sure.
But I'm trying to ensure that we make these diversion programs as effective as possible, and that's why I don't allow it. I'll just let you know, counsel. I don't allow people into my diversion programs on a no contest plea because, well, they're not taking responsibility. So
Sure.
that's
and
why.
Your Honor, I understand, Your Honor. I don't think that's at all what we have here, and I'm hoping that my client, who completely
Well,
understands,
let's go. Let's hear what he has to say.
Your Honor, I'm completely, absolutely 100% taking responsibility for this. I absolutely understand that I may have placed maximum reasonable apprehension and that may have threatened him. And I absolutely feel horrible for my actions. I absolutely want this diversion program more than anything. I really want this for my life and for this to go this way more than anything. I really am begging for mercy on this and pleading and praying with God every minute that I can go in this direction and have this so I can move on with my life and I can go on and enjoy my son's birthday party with him today, and we can move on in a positive direction and I can receive the help that I need in my family. We can move on.
Your Honor, may I clarify 2 points with my client? Mr. Akey, you mentioned that you may have but you did engage in sort of intentional
I do
conduct.
understand that, Your Honor.
Let me finish my
Sorry.
question. You did engage in intentional conduct towards your son that you knew was placing him in fear of immediate contact. And you understand, Mr. Rickey, that that was inappropriate.
Yes, Your Honor, Mr. Townsend.
Okay, I just want to make sure, because
I
you said
do
may
understand
have.
that. I'm so sorry. I do
Okay.
understand that. Absolutely, 100%, and taking full responsibility. And begging for this diversion program, please.
And that happened, the things you're saying
These
happened.
things, yes, 100%. I'm taking responsibility. They happen. I'm not trying to say they did not in any way, shape, or form, Your Honor.
Okay. Thank you, Your Honor.
Mr.
Thank you for the patience.
Mr. Duffield, are you satisfied with the plea?
I am satisfied with the plea, Your Honor. Thank you.
And Mr. Townsend, I believe you already stated you were satisfied with the plea.
I am, Your Honor, and again, thanks to the court for its patience in allowing us to speak.
Any further recommendations, Mr. Duffield?
Just, I do think, especially based on the statements just made, that Mr. Akey would be a good candidate for the court's diversion program and would encourage the court to sentence him thusly. Thank you.
Thank you, Mr. Duffield.
Mr. Townsend?
I agree with the prosecutor's recommendation, Your Honor, and particularly in light of what Mr. Akey has said here today and his lack of criminal history. I do believe this is a blip on the radar for him. He knows the seriousness and the importance of what's gone on here, and I do strongly support this request for diversion. Thank you.
And Mr. Akey, anything further?
No, Your Honor,
Okay, that's fine.
I understand.
All right. We'll go ahead and place this into the diversion program for a period of 12 months or $625 oversight fee associated with it. Purpose of probation is to provide the defendant with counseling, anger management, and or batterers counseling to enable you to learn how to deal with anger impulses and flashpoints, to be able to engage with individuals with whom you have a domestic relationship in a constructive and civil manner. The no contact in this matter has been adjusted to non-assaultive contact, and that will be continued. Upon completion of the diversion program, the case will be dismissed from the public record. The $625, I'll give you the period of probation to take care of that, but whenever you'd like to is fine. And do you have the number for our probation department?
I don't believe we do, Your Honor, but we can certainly get that from the court.
It's 269. Make this stick.
Yes, sir, Your Honor.
Good luck to you. You can leave the court.
Thank you, sir.
You're welcome.
Thank you, Your Honor.
You're welcome. So on the record, in the matter of Clifford White, let's have appearances, please.
Good afternoon, Your Honor. John Duffield for the people.
Good afternoon, Spencer Ledoux appearing on behalf of Mr. White under court rule for sentencing.
Okay. Mr. White, state your name for the record.
Clifford Daniel White.
All right. Mr. Duffield.
Thank you, Your Honor. My understanding is that Mr. White recently pled to operating while intoxicated as well as speeding between 20 to 25 miles an hour over the speed limit on a highway. I have reviewed the assessment provided that Mr. White completed. Based on that assessment and the facts at which led to, or the allegations which led to this the sentencing, I am concerned about the behavior, that the risk that the defendant's behavior posed both to himself and to others. My understanding is that he was seen weaving quite fast on the highway in and out of traffic and was eventually stopped. The numbers I had from the Intoxilizer report were 0.214 and 0.224. With that in mind, I would ask for a period of 12 months probation, as well as any rehabilitative or alcohol and traffic safety programs that the court thinks the defendant qualifies for and would be appropriate. I would also ask for a period of, for approximately 100 hours of community service. I know that sounds like a lot, but the statute does allow up to 360 to be awarded. And given the risk that the defendant posed both to himself and others, I believe it would be more appropriate and more useful, frankly, in this circumstance than any jail time request. Regarding any other issues for sentencing, I would leave that to the court's discretion. Thank you.
Mr. Duffield, thank you, Mr. Duffield, Mr. Ledoux.
Thank you, Your Honor. Mr. White is currently in therapy for substance abuse and mental health issues. He started this 3 months ago through Cherry Health. He goes every week. He understands the severity of the plea. He does want to make sure this does not happen again. And for those reasons, we are asking for fines and costs only.
Mr. White, what do you have to say?
Sorry. Can you hear me okay?
I can.
Okay. Yeah, I definitely understand the severity, and that's why I sought out help for myself on my own, because I'm trying to get to the bottom of some mental health issues and some substance abuse issues that I've dealt with for a long time. I am getting a lot better. My therapist really supports me a lot. It's up to the court what you guys think is fair. I do want to make you aware that I am getting a sentence in a Kent County case the 28th of next month, and there's going to be probably 6 months to a year of jail time behind that. So I don't know how that'll tie into this as far as if there's probation. I don't know how it'll work, but I'm willing to do whatever the court recommends, Your Honor.
Are you willing to get out of bed and sit up?
Carol, I think that the speeding charge, I've already went ahead and sentenced that, correct? I don't have it here in front of me.
Your Honor, I believe it's $150 fine or something.
He pled to that, and payment is due on it.
Okay, so I already assessed that. That's fine. All right, so we're going to assess $100 for the Need 6 survey, place you on probation for a period of 12 months or $360 oversight fee associated with that. Victim impact panel will be required, but I'll get to that in a moment. Purpose of probation is to address substance abuse issues and provide the defendant with the resources, counseling to attain and maintain sobriety. You are required to attend and complete counseling as ordered, as well as submit to testing as ordered. Randomized testing is a part of the order of probation. You are required to attend the victim impact panel, as I mentioned earlier, as well as the highway safety alcohol course. You are prohibited from possessing or consuming alcohol or any illegal controlled substance. You are entitled to early discharge upon completion no less than half the period of probation, but that's only if you fully comply with all the terms and conditions of probation. Fines are $300, state costs are $50, statutory, the court costs $400, and the crime victim right fee of $75. That then would be a total of $1,285. And I'll give you 1 year to take care of that. Well, I'll give you the period of probation to take care of that.
Your Honor.
Now, you indicated that you're likely going to jail in Kent County. If that does indeed happen, make sure you're communicating with your probation officer so she doesn't think you are just suddenly going silent on her, and we can deal with things forthwith in that manner. Perhaps we can coordinate something with Kent County, or I don't know, but
I wonder if it's for similar charges.
the point is communication is your friend in this circumstance.
Okay, Your Honor.
Mr. Ledoux, thank you for the recommendation. Considering the reason I went the way I did, just so you have a little bit of a basis of it, on that is associated dangers with this matter, with the speed associated. I just think it's really important for public safety to have this as a for accountability and hopefully preventative measure to make sure it doesn't happen again. So just, and that's just for your edification, going into your points were certainly well made. That wasn't that I wasn't listening to them, but there are some certain ground facts that even defense counsel don't have the ability to change. So we just need to address that from a public safety point of view. All right.
Thank you, Your Honor.
Mr. White, you can leave. Do you have the number for probation, Mr. White?
It's probably online. I could probably find it. Or
I can tell you with a note right now.
Okay,
You
hold
can
on.
punch it into your telephone. It's 269.
Hold Hold on one second. Let me get my other notepad out. 269,
Correct.
and that's Allegan District Court probation.
Correct. All right, you can leave the court. Good luck to you.
Do I call them today?
Call them right now.
Okay, thank you.
You're welcome.
All right, good morning.
Good morning.
Okay, Mr. Johnson is here. Well, I'm gonna go ahead and go on the record and then
This is so much fun, you guys.
figure out what's going on here. We're gonna go on the record in the matter of the marriage of Kathy Jo Johnson and Wade Douglas Johnson, 2025 DM 165. Summons was served June 18th on Mr. Johnson. The time to answer has elapsed. The petition for divorce was filed pro se by Kathy Jo Johnson, the petitioner. Both are self-represented. Was filed on 5/12 of 25. So we're just past 60 days, which is the waiting period for divorce in Kansas. It's a petition for divorce without children. It indicates she's been a resident of Kansas for 60 days. She reports living on Sunset, I think. Yeah, Sunset Lane.
I have my own place now.
Okay, you're not on Sunset Lane?
No, ma'am.
Okay, because you had him at Street.
Yes.
Is he still there?
Yes.
Okay, this is a short-term marriage. You were married in 2022?
Yes.
Okay.
Yeah.
No one's in the military. You want your maiden name restored.
Yes.
Sir, do you own this property on Street?
Yeah, I'm buying it
How are you buying it?
through a bank.
Okay, so everybody's usually buying their house. So do you have a mortgage?
Yes. I'm sorry. Yes.
Okay. When did you purchase the house?
I got it into my name in like 2017.
And you have a mortgage with the bank or an individual?
A bank, Wells Fargo.
Okay. How much do you owe on it?
78,000 left.
When did you get the loan? In 2017?
Yeah.
Okay.
Refinance it back into my name.
Oh, let's see. From a previous divorce or something?
Yes.
All right. Ms. Johnson, did you enter the marriage with any real property? Any real estate?
I did not.
Okay. Are you making any claim for any value associated with this property from 2022 to present?
If I'm entitled to any, yes.
Well, listen, I can't give either one of you legal advice. You
Okay.
filed this yourself without consulting with counsel or retaining an attorney. So what I can tell you is that it is marital property.
Okay.
What, if any, you might be entitled to or a judge might award you, I have no idea. Typically, an attorney will look at the value of something at the time of the marriage, the value of it at the time of filing the divorce, and then whatever increase in value, they will generally argue for 50% of it. But not always. And if I'm a lawyer and it's going to cost $10,000 or $20,000 to sell a property and that's all the equity there is, then unless there's some other stream of or avenue for liquidation or monies, it probably isn't a very viable option.
And let's just be real. If you come into a marriage and your partner already owned their home for several years prior to you coming into the marriage, and you make them sell that house just so you can get a little bit of cash. I'm sorry, for a marriage that lasted, like, what they said, 3 years. Sorry, that's a jerk move. That is a total jerk move. I don't care if you're entitled to that couple $1,000s or not. It's a jerk move. Earl, I need to click the button. Get the butt out of my face so I can click the button.
I just can't. All I can tell you is that you will have to quit claim this property to him for him to have free and clear title. And it's going to have to be awarded to someone in the divorce. So and you have to do that by agreement, or I have to hold an evidentiary trial where you come into court and present evidence and then I make a decision. I can't off the cuff here act as an attorney or a mediator and negotiate this divorce with the two of you. The boundaries are pretty clear for judges and attorneys and parties, but when forms are made available that people can access the courts easily and just submit stuff to it, it makes it hard to traverse and maintain the neutrality that I need to have and my actual role. Okay. The other thing that I'll mention is typically the only other area that could be large monies are investments or 401ks and what was put into them during the term of the marriage. Sometimes in longer term marriages, the biggest asset in a middle-class family can be their retirement. There is entitlement to that. I mean, there are other things that you may not realize that you may or may not be entitled to without having consulted with an attorney or gone over all of it with an attorney. So I don't have a journal entry submitted to me that you're wanting me to sign that's agreed upon, or if he didn't appear, respond that you could request by default. So I don't know what direction you plan to go today as far as your divorce, but let me look here at your DRA. Wade, are you not employed?
Yeah, city of Wichita,
Okay. How long have you been there?
30 years.
Oh, wow. Okay. May I ask what you do there?
Operate a street sweeper.
Okay. Yeah, I'm sure he's got, do they have capers or their own retirement?
I think it's like a capers. I think, I don't know.
Okay.
I
Well,
don't remember. They've changed other things, so I think it was a capers.
This says you don't have any money in savings or checking. You only had $50 in moving expenses. That's pretty cheap. This Toyota is yours, Kathy,
Yeah.
Yes,
and you're making the payments.
yes.
Okay, and you want to keep that? Is that solely in your name?
It is not. It's in both of ours.
Okay. What? It's a 2020.
2018.
Okay. I doubt it's worth a lot more than what's owed on it.
Right.
Okay. But again, that's stuff that has to be researched. What's the Skyward?
I have a truck loan through them and a signature loan through them.
Okay, and that's yours?
Both our names are on everything.
Okay. But okay, yeah, I need to know that, but I'm just wondering.
I have the truck. I have a truck through Cessna, a signature loan through Cessna. I have the Jeep payment through Wichita Federal, and a signature loan through Wichita Federal.
Okay. Well, generally speaking, I just lost you, but generally speaking, if, to make it real simple, if somebody drives a vehicle and they've had pretty much exclusive, everybody's generally got their own vehicle and whatever's owed, and if they're making the payment, then they keep the property, but they make the payments too. Rarely is there a lot of value associated with vehicles and things, but occasionally, it's worth more than what's owed on it, and the person, may want some claim against it. But usually you take what you got and you pay for it. But both people are responsible unless you convince whoever gave you the loan to refinance or take the other person's name off of it. I cannot order a bank to take your names off things. When people, whether they're married or not, enter into contracts with creditors, a judge can't come along and rearrange that. I can order that it be in the possession of a certain person. I can order that certain person make payments, but if they don't make payments, the other side has to, that loan company can still come after you. And that other side has to come to court and say, well, I want them found in contempt of court for not making the payments on property that they took. And then you have to do a contempt citation, and I have to bring him in to show cause. And I have to make a finding that they're capable of making the payments. They're just refusing to do so. And then I can fine them or ultimately jail them, which generally only happens with child support. But I cannot change the configuration and the legality of a pre-existing contract. So that's going to be up to you to figure out, how you're going to do that and be comfortable with that. And, I can't give you advice. You could just leave both names on everything as you make your payments and make a commitment to pay your stuff off. And then everybody's name goes off of it. When it's paid off, it looks like he actually owes more probably than you do.
And if you can trust the person to make the payments, that's probably the easiest way. But if you've got someone who is a little, lazy daisy on making their payments, then you best get them off, because your credit's at stake too.
Yeah,
So I wouldn't want to remove him from the name on my car if he hasn't removed you from the name on his stuff, which is in excess of what you owe. But you two are going to have to talk about that, or you're going to have to plan to come to court and bring in documentation and make arguments and litigate it and let me decide.
I think we both agree that the vehicles stay with, like I keep my RAV and he keeps his truck and his Jeep. Right? We agree on that.
Okay.
I know I do.
And then
One we thought about leaving my name on her RAV because she is having, with her credit score, her trying to get it refinanced into her name. Have you looked into that more about getting my name off of it, or is it easier to keep my
Toyota
name on it?
Financial said they do not change it at all. I would have to refinance it with another company, and my credit score is only 680, so I don't hold strong without weight on it.
So will you keep doing the payment like you've been doing?
Yeah.
I can agree to this, Kathy, because you've been doing all your payments and stuff, but then when you get mad, that the credit score.
I make the payments.
Us.
Make the payments. That's the
I know.
quit scolding her in court, in public. I'm sorry, but no.
Just missing a payment hurts our
Well,
credit.
again, I wouldn't take her name off of your stuff either until her stuff's paid off. I mean, it should be
I know.
a quid
I
pro.
just, that was one with Kathy, is I know it was easier to keep my name on it. As long as she keeps doing the payment
All
right.
right, then, and you're gonna take the signature notes, were those for something that you utilize the money for? I mean,
Yeah.
a judge normally
There's
looks
two-
at manner and looks at manner and method.
There's two of
act-
them, Your Honor, and I don't know what they're for. I know what one's for side by side, but I don't know what the other one's for.
The other one was for the boat. I forgot
boat?
what that one was.
The
The
boat.
aluminum boat.
I signed a signature a loan for a boat.
No, I had that prior to me and you. But when I did the side by side and the RAV and all that stuff, and what Cessna talked about trying to bring the RAV over there to you, everything got added on as us as a couple. So your name is on it.
Oh,
Nothing has changed.
Okay.
Everything's been paid out of mine. As soon as the check hits the bank, all my loans get paid.
Okay,
and the side by side we got together for our grandkids is what he said. So I think if it would be fair if he kept
Playing
one
out here on
signature, but his
We're
boat
out
and I
here
got
on the property.
well, here's,
We got that for being here.
okay, here's what I suggest you do. I suggest you start emailing each other proposal on how to resolve everything. And when you have it, my AA printed out a decree of divorce, but I'm not going to fill it out. That's for you to fill out. I'm definitely not going to fill it out. I mean, I would fill it out if you were in agreement on everything and you told me what to put down or her to write down on here and you looked at it. But I'm not going to do the work for you and negotiate your divorce while you're in a hearing. I can't do that. So you
Did
two
you
are gonna
answer
have
that?
to agree on all of this stuff and write it down or have it written down and present it to me, and then I can approve it.
Did he answer back? Like, should I have received what he was wanting in the divorce? Because I emailed Amy what I wanted. Did he answer back?
He is not
Yes, I
filed.
have. I emailed Amy with it.
I think it'd be easier if I seen what he wanted and he's seen what I wanted, maybe.
Well, here's the deal. When you send something and file it with the court, you have to send it to the other side. He should already have it.
But we have a no contact order. I didn't think that we were supposed to be agreeing on stuff right now. I thought we would get in trouble if we were talking. So maybe the no contact order needs to be dropped so we're able to talk without getting each other in trouble.
Well, I think you're acting as attorneys. If you had attorneys, you would not talk at all. The attorneys would talk. If you had one attorney, one of you would talk to the attorney. So again, I don't know the depth of your problems, and I don't know, most people normally used to go to a lawyer and get legal advice, and the attorney would work through these things with them, and something would be presented to a judge, okay? So I don't know the degree of threat either one of you are to each other. I know that there's a mutual order of restraint in here. But the only way but we are not going to facilitate, and my AA is not going to facilitate you're negotiating a divorce. So I suggest you email each other where there's a record and proof, and your contact be limited to emailing one another exclusively about settling these issues to get your divorce, or go retain an attorney.
If we can't agree, I will retain an attorney. So I'll email him. I'll try to get along, but if we can't do it, I will retain an attorney.
Amy, do
I
you
need to
have
know
that he filed? Because there isn't one in the court file, and all I'm not looking this up on the computer. You know, I'm kind of old school in that regard. but I take the files and hope that the information is in there.
A formal answer was not filed. The last thing filed in this case was that personal service of the summons, the return on 6/23.
Here's the other thing, folks. My AA is not the clerk of the district court. When you want to file pleadings and make progress on your case and file answers, you file it with the clerk of the district court, not the judge and not the AA. She's
Our
not
last,
the go-between person. That's for you to take care of through the clerk of the district court.
our last meeting, you said, I said, how do we do that? Email it to Amy.
That's why I emailed Amy.
Okay.
And the
I
email,
may have said, because you have this order of restraint, that you could suggest a proposal and she would forward the email so you two didn't have contact. That is not really a very good idea, but doing that is not an answer. And what you said to me, Mr. Johnson, is I filed an answer and I filed it with Amy. You did not file an answer in the court file, and you do not file things with Amy.
That's the way I took it our last meeting that we all had together.
Okay.
You said, send your request back in.
That's
So
not, that's
is
not,
that what you're not? Okay. Kathy, is that not what you did too?
I did it because that's what I thought we were supposed to do.
Oh my goodness. Hey, guys, they just agreed on something. Progress.
I did too.
all
I'm
right.
sorry.
We
That's what I
aren't
took it.
doing it anymore because you haven't made any progress and we are not going to be involved. Okay. I would have thought that if I gave you instructions, which I'm sure I did, I'm not doubting it, that you would have done it, it'd been done and agreed to and taken care of, and you showed up for court today with your hearing ready to go, and I would have already had your divorce done. But
I
you
did
don't.
answer that. He didn't. I did.
This isn't the only divorce we have. This isn't the only case that we have. So are you both agreeing, because you're unrepresented and you're representing yourself and you're trying to complete your divorce, that you can email one another to propose a settlement of your case and get your divorce?
Yes.
Yes.
All right. Do you have each other's emails, or do you want to create your own email just for purposes of this case?
I have.
I
Okay.
think I have hers.
Do you have the same emails that you had when you were married that you haven't changed?
Yes.
I do.
Okay. Amy, did you receive something from Wade that Kathy didn't get that should be forwarded to her?
I have forwarded what I have received from Wade. To clear that up, Kathy did send me an email on 5/26, which is a very clear list of things that she would like, property. That was forwarded to Wade. Now, the emails that I received from Mr. Johnson were talking about her needing to get her name off of certain things, pictures of electric bills, him stating her being behind on bills, not necessarily a list of specific things that are in her possession that he wants.
Okay.
But I have forwarded, I went ahead, I did not forward those to her because it wasn't a list of things that he was looking for. Now, I just forwarded them at the beginning of this hearing. So she has the 3 or 4 emails that he sent to me, and it's talking about paychecks, electric, propane, trash, stuff like that.
Okay. So look,
None of them built in my name.
I try to be helpful. I assume that folks are filing their own divorce, not because they think they're as smart as a lawyer, but that they apparently are in financial shambles and can't afford lawyers. I'm sorry if I'm being short with you. This is just very frustrating because it's not just your case, it's everyone's case that they just want to dump it on the AA and the judge. And I cannot do things this way. What you're asking Amy to do is what an executive assistant does for an attorney on both sides. And that's communicating and negotiating a property settlement and all of that kind of stuff. And I must have thought in this last hearing that you just had a few issues that maybe you could exchange some information, quickly resolve them. But you don't. And that's not what's going on here. You're going to have to do it yourself. She doesn't have time to work as my AA and work as you guys as assistant. Again, I'm sorry. I don't mean to be short with you, but I don't know how else to express how difficult this makes the situation when you two are not in agreement. And the only divorces I can do is one that's in agreement, or schedule it for a trial and you come try your cases. Okay? So we didn't get it accomplished. Whatever I said to you on May 15th that I thought might occur to get this thing completed did not happen for whatever reason. So you need to have your debts agreed upon, who's taking what. You need to have your assets agreed upon. Or I will schedule a trial date for you and you can come into court and bring your bills. You have to bring all the documentation and you can present what you want, each one of you. And I can decide. I'm happy to do that, but it's got to be a full evidentiary hearing in a courtroom on the record with documents and testimony under oath for me to be able to decide anything.
Okay. So
Okay.
can I get this clear real quick? So Wade and I are gonna try to agree to stuff on an email. If we can't agree to it, do we go down and file it with the clerk at the courthouse?
No, you schedule
What
a
do we do?
trial. The only thing that now needs to be filed is he really needs to file an answer. I mean, again, in these pro se cases, when someone appears after they've been served, I consider that an answer and an appearance. Because generally when they self-represent, if they have not talked to a lawyer at all, they don't realize they need to go online, get the form and file an answer. But answers are supposed to be filed to preserve your standing to litigate your case, frankly. And that just gets filed with the clerk. The rest of this stuff happens without us, through lawyers or through parties. And when it can't be agreed upon, they schedule a trial date and you put your case together and you come into the courtroom and you try your cases and I make a ruling.
If we agree on everything, do we file that through the court or email that back to Amy?
Okay, this is, you go back to these forms you started with and you continue to use the forms that you started with. And there is a decree of divorce without children with real estate. And Amy started it so that we could get this accomplished, but it's got to be filled in. So you fill this in and you both sign it and you submit it to me and I review it and take some testimony, find that you're incompatible, find that you should be granted divorce, find that your division of property is fair, just, and equitable.
And do not submit it with lots of whiteout and things crossed off, as we learned the other day.
Find that the court has jurisdiction and find that there are no children, and we're done. And I filed this after I've signed it because I've approved it.
Kathy, did you print that stuff off?
I'm not crazy about these forms in every aspect, but they work. And that's what the Supreme Court's put out. And the reason they did that is because people were buying stuff online from other states that didn't apply. And so they thought if people are going to file all kinds of documents, we might as well put together some forms that comply with Kansas state law. And this is what we got. Okay. So I will have Amy email this to both of you so you can see. And if you can come to an agreement by emailing without violating the order of restraint to not harass each other, show up at each other's property or work or that kind of thing, then email one another, see if you can't get this taken care of and negotiated, fill it out. We'll schedule a new hearing date, come in and take care of it and get it done. Otherwise, you call Amy and say, we need a trial date. We've given ourselves 30 days or 60 days. We've been back and forth. We cannot agree. And like I said, the person who presents the best case is probably going to win in court. But you got to come into court and we got to go through the motion of hearing that's due process for both sides.
Okay.
Okay. All right. You all have been through this before. Like, how many times have you both been married?
I was once, and I got divorced when I was 20. So I stayed. Yeah, I'm new to this.
Okay. Wade, you've been married 4 times.
I can't afford a lawyer.
Okay.
Look at the price of lawyers right now. They're crazy. And nobody even in El Dorado.
Okay. But you do know kind of how it works.
Yes.
Right.
And at first, me and Kathy were talking and we are going over everything and we were trying to do this together.
Okay.
Wow. You know, 3rd time wasn't the charm. Neither was 4th time. I think you just need to date for a long time, sir. Because clearly your method is not working. And divorces they're expensive. You can lose half your stuff. You don't always come out okay in it. So I think you just need to either stay single or date for a long time. You can get engaged. Stay engaged. That's my fiance. It sounds good. Yeah. Wow. 4 times.
Why did I do an order of restraint for you? Did you guys start with a PFA?
Yeah. PFS.
That's the other thing that happens. People want to do their divorces through a PFA. Well, that's not what they're for. And then if we can get them in the divorce case to save everybody's job, calm things down, have an order of restraint. And that's probably why I said email it to us, because I get nervous because I don't know the degree of what's going on between the two of you and how toxic it might be. And so I don't want to encourage you to be communicating and then have issues about stalking and violating protection orders. So again, that just is another layer of complication. But if you can assure me and you're comfortable and you can email each other, that's what I need you to do so that we're out of the loop like we're supposed to be until the case is ready to come to us. Okay?
Okay.
So this is being sent. You guys talk. That email is going to be your documentation, though. If anybody gets nasty with the other person and carried away or threatens the other person, I mean, it's going to be evidence that I will accept because you're emailing each other directly for purposes of this case. So I know that won't happen, but that is the way that I can. That's why I don't want you on the phone or doing it texting or some other way that I can't follow the conversations. Now, do you think Do you want to call and get a hearing date when you're ready to go? Is what I'd prefer, except I don't want to lose track of your case.
I'll give it 30 days, and then if we can't come to an agreement, I'll call either way.
Okay, you'll call and schedule a trial.
Yes.
I think with what you have here, the case could be tried in a couple of hours, 2.5 at the most. So I would give you a morning or an afternoon. Usually I'm about 45 or 60 days out in getting blocks of time for people. Unless something cancels, but that's always last minute and I can never get people hardly scheduled in those time slots when they cancel the day before. But I can get you a trial date within 45 to 60 days, probably pretty easily for a couple of hours or so, or a morning or an afternoon, within 45 or 60 days from the time that you notify us that you want a hearing date.
Okay.
Okay, fair
Okay.
enough?
Yes.
Okay, sounds good. Let us know.
Okay.
Okay, all right, thank
Don't talk to him.
I will stand
Wait,
up.
hey,
No, I was just saying, I'll stand
no,
up.
shh, quiet. Just listen. We're gonna get through this.
Dang it, I was muted. All right, guys, we're going to pause because we are going to pop on over to Old Squishy Gardener's channel and we're going to watch the hearing for the motions right before this. And dag nabbit, I wish I had realized that it was from yesterday's, because I did have it. And I was so sad. Hold on, I can do this. I know what I'm doing. I'm a professional. Okay. Is it? Oh, hold on. I can't read it because the timestamp's over it. Hold on one second. I can't see chat. OSG. Oh, you DM'd it to me. You're amazing. Hold on one second here. There it is. Hold on, let me pause. Move this back. Go back over here. Share screen. Thank you. Thank you so much for sharing this with the chat. You are so great. I appreciate it. I really do. All right, so. Most inept sovereign idiot fires another attorney.
Mr. Martin. All right, Mr. Martin, can you tell me your first and last name?
Of course, I object. I'm not the defendant here.
Then I'm going to issue a bench warrant for your arrest. You're here. I'll recognize you. You're Mr. Martin. Okay. I understand. Let me ask a few preliminary questions. I know, Mr. Gazicki, you need to make a record. Is the complaining witness present for today's bench trial? Okay, okay, thank you.
Two issues. One on discovery. We were here about 2 weeks ago. I did receive discovery, I believe it was like June 23rd or so on. I've been on vacation since the 3rd of July until yesterday. I had no opportunity to go down to the jail to visit Mr. Martin. But with, today, I handed him a redacted copy. because according to the discovery procedures in Wayne County, the only files I can share with the defendant are redacted. As far as the video goes, I have no other means to, redact that, to show that, or to give him a copy. Today I handed Mr. Martin a redacted copy of the police report that I did have. Okay.
Mr. Gadzicki, how dare you go on vacation? Don't you know the world revolves around Mr. Martin? Shame. For shame.
With that aside, Your Honor, I do want to make a motion to withdraw. I have had contact with Mr. Martin in the past and ended up with the same position I am right now. There's no communication between the two of us. There's, different thoughts on how to proceed and so on that I cannot adhere to. So I'm asking the court to withdraw on this matter.
Mr. Martin, have you had a breakdown with your attorney?
No, he's not doing his job, so like as he admitted, he hasn't brought me to discovery, so I just told him I'll file a motion to dismiss the case, then based on the ineffective assistance of counsel.
Okay, well, you can't dismiss a case on that. I'm asking you a specific question as it relates to Mr. Gadzicki. Do you want him removed from your case?
As long as he's not gonna do nothing that's gonna jeopardize the case further, like try to delay, like he asked me, do you want to do adjournment? I said, no, I'm not doing no adjournment on the trial. I'm just sitting in jail. I'm waiting. So I don't consent to him doing nothing that's gonna jeopardize or violate my rights. But as long as he's doing, what he's supposed to besides it, I have no problem with it. But
well, you understand, Mr. Martin, I've told you this previously. Attorneys it's against the court rules for them to file frivolous motions. So Mr. Gadzicki cannot, as your attorney, make motions that are frivolous. And some of the motions that you've previously presented to this court are in fact frivolous. Okay, I have jurisdiction. So if you're asking Mr. Gadzicki to file a motion on the basis of jurisdiction, he cannot do that. Do you understand what I'm telling you?
the one I didn't ask him to file a motion to dismiss criminal jurisdiction.
Well, you've asked him to file a motion to dismiss today.
No, I didn't ask him. I just told him I was going to do it myself. That I was going to file the motion to dismiss the case because of this ineffective counsel not providing.
Okay, that's not a reason for a dismissal.
Sure.
Okay, so Mr. Martin.
I'm gonna move, well, if it's right now, I'm gonna move for that, that's why we're talking about it. Or
Okay, denied. What's your next one?
Based on what reasons?
Okay, so do you want Mr. Gadzicki to represent you or not? Yes or no?
I'm gonna say no.
Okay, there's been a material breakdown of the attorney-client relationship based on both counsel and Mr. Martin's assertions. So Mr. Gadzicki is withdrawn from the case.
Thank you, Your Honor.
Yeah, thank you. Now, Mr. Martin, you have to make some decisions. Do you want an attorney appointed to represent you on this? I know
Unless one's immediately right now, no, because I'm not gonna allow a delay in this case due to
well,
these
Mr.
incompetent
Martin,
attorneys not doing their jobs constantly.
Mr. Martin, you have a constitutional right to an attorney. If you can't afford one, I will appoint one for you. Do you understand that?
I comprehend that, yeah.
Okay, so here's the thing. I don't want you to say that you don't want an attorney because you want to go to trial right now, unless you have a true understanding of what that means. Because you can't go back later and say, well, now I want to appeal because I wasn't given counsel because I said I didn't want counsel because I want to go to court right now. Do you understand that?
Well,
I'm happy to adjourn this for a week so that you can have an attorney.
Why I sit in jail? No, that's I don't agree with that. So no, I can present myself. I've been doing all 30 years. I didn't practice.
Well, it's not been going very well for you, Mr. Martin. It might be time for you to get an attorney.
No, I don't agree with that. I've been beating several cases myself.
Okay.
So regardless of that, this is a simple case anyways.
All right, Mr. Martin, listen to me. You understand. I want you to understand a few things, okay? Again, you have a right to an attorney at public expense. We could expedite this case and put it on a docket right away. It's a bench trial. So I could get you on, next week or later this week. I'm not certain if that's possible. It would likely be next week, so that you could have a lawyer and that lawyer could represent you. And I want you to think about that, because
Okay.
Mr. Martin, if you have a constitutional right to a lawyer or to represent yourself if that's what you want to do. But I need you to take the passion out of it, take the heat out of it for a minute and think about what you want to do as a smart decision. Do you want to wait a week for a trial and have an attorney present or not?
No, I don't want to delay this because there's no guarantee the next attorney may do the same thing. Just keep on not doing their job, and then think they're gonna delay me. So no, I'm ready to go forward. And I have,
You understand, Mr. Martin, that if you chose to represent yourself at this hearing, you're held to the same standards as an attorney. And do you understand that?
no, objected under Haynes versus Kerner, U.S. Supreme Court case. Pro se litigants are held to less stringent standards than formal pleadings drafted by lawyers.
Okay, well, this isn't a formal pleading. These are questionings of
Well,
witnesses.
it's the same
Well,
thing.
no, it's not the same. I want you to listen, Mr. Martin. I'm trying to make sure your rights are protected right now. I'm asking you to get an attorney. You've indicated you want to proceed without one. And I'm asking that you understand, I'm not going to allow you to get up here and ask questions in a way that are inappropriate to witnesses. You can ask questions, you can get answers, you can ask more questions. But I'm not going to allow this to meander into something that it's not. Do you understand that?
Well, I do my best. If it, do something, that comes that you let me know or whatever. But of course, I know the basics of presenting a case, be it criminal or civil. So,
Did you go to college for 7 years to be a lawyer?
Not official college, but when I was in prison 24 years, I studied the law library for 24 years straight.
Okay.
30 years now counting, so.
Okay.
There might be a
That's
few
your
things I might
choice.
forget.
If that's, Mr. Martin, I'm not, look, you and I have gone back and forth for several hearings at this point. I'm not going to change your mind on things. I know that, right?
Right, yeah.
Do you have a right to a trial? You have a right to a trial by jury or judge. You've previously waived your right to a trial by jury. Is that correct?
Right, yeah.
Okay. And so
Since
here
I'm
we,
not gonna get a jury by like I really want, a jury of my peers to be those of the sovereign people, since that was denied before Slaton's court. Same.
yeah, it's, do you know, where am I supposed to go to get a judge of, a jury of sovereign citizens? I mean, that's not how it works. That's not what the Constitution requires.
Internet.
So you're waiving your right to a trial by jury, correct?
They're all on the
Because
internet.
like I said, I can't get a jury by my peers of sovereign people.
Oh, okay. And are you waiving your right to an attorney?
As of now, but let's say, worst case, let's say even though I shouldn't, there's no evidence, even if it was to be guilty, I would then want an attorney to represent me on appeal, I'll say that. But-
Okay, well, I want you to know that you would have a constitutional right to have that attorney too.
Right.
And
But
if
as
you're
of now,
found-
no, because these attorneys keep, like I said, they keep doing this, it's constant.
Okay,
That I've been having, not doing their job and holding me up, I'm not.
Okay. All right. Is there another, Officer Frisky, Officer Kemp, can you come up for a second? If you can stay with the prisoner.
But also I need,
Give me a second, okay?
I'm sorry. Yes, I know. I'm sorry. I was maniacally giggling for the longest time. That's all I could do was giggle. Because, yes, you're going to enjoy it. Oh my goodness. Thank you so much. Yes, I said I've only watched about this much of it because OSG so graciously shared it with me. Oh, yes, that is my plan all day long, man. Oh, it is so humid in here. Oh, golly, I need to go wash my face. Okay. I'll be right back after I get this going.
What's that?
Was this case started at all this morning?
All we did was he made his motions for dismissal. Yeah, and now we're ready to actually start the trial.
Okay.
Unless he has more motions for dismissal, but after that. I want to apologize for the wait we had there, Mr. Martin. Did you have a chance, Mr. Martin, to watch that video?
I've seen the videos that, of the cop going in my house.
Okay, so
But
you,
there's still, but not the video of the other court case my sister.
well, I told you I'm not
Judge.
entertaining video from another court case.
Even though it attacks her credibility, but I don't know.
Okay,
Okay, well, anyways, yeah, on that, but, there's something.
okay, well, wait 1 second. Can I get your appearance, counsel?
Yes, Your Honor. Good afternoon. Natalia Asmer on behalf of the people, PA8493.
Okay. And, Mr. Martin?
I missed her, but, I object to the mister, because the mister will understand what, understand, but
Okay. What's your first and last name?
it would mean that I'm, not one of the sovereign people, and I am one of the sovereign. people.
Okay, well, you're also a citizen of the United States, and you have a birth name, and it's Eric Martin. I'm familiar with you all except your appearance. All right, any other preliminary matters before we start testimony?
No, Your
Yes.
Honor.
All right, go ahead, Mr. Martin.
Yeah, some motions, but, one of the things I need someone to testify for, and that's the tax assessor, Jessica here, that's next door, which supports, my sister being a liar.
All right, that's not relevant.
Her not lying is not relevant, that doesn't make sense.
You can ask her questions about
No, I'm not
that.
talking about my sister, I'm talking about the tax assessor will admit something, if she's questions which the quickest, easiest way would be like you call her, or I need to call her, subpoena her in the court to testify to something, which will.
What, give me an offer of proof. What is she going to tell me?
She's gonna say the house's name, I mean, the 9074 Clifford Street where we live at, that house is in my father's name, which this is what Jessica told me. This would support my sister's lie, how she keeps on saying, it's my house, it's my house. She's all in the video saying that 1,000 times.
Okay,
So that would attack that she's a liar, which would attack her lying allegations in this complaint that she's a liar, and therefore it's relevant for that.
ma'am, can you stand and tell me your first and last name?
Lisa Martin.
Miss Martin, is the house in your father's name?
Yes.
Okay, that's it. That's all I need to know. All right, I'll take judicial notice of that,
Okay,
that
thank
the
you.
house is in your father's name. Anything else?
No, not as to that, no, actually, no, I have some motions now, yes, besides that.
All right, Mr. Martin.
And, okay, I move to dismiss based upon, my right to slavery, against slavery, that is, under the 13th Amendment. These proceedings from the jump have been proceeded against my consent. I never consented. If it's ever fraudulently assumed I consented, again, it's fraudulent. And it's not true, and therefore violates my right to slavery.
Okay, denied. Next.
Um,
Mr. Martin, I'm going to start taking testimony soon. I've entertained about 10 motions to dismiss from you already this morning, so.
I have one more. No, that's about, I have one more. That's all I can think of right now. I reserve my right to bring it up again if I think of it.
All right, at the end of the prosecutor's case, you can bring a motion if you have one, okay?
Okay.
All right, any other preliminary matters?
No, Your Honor, I did just want to place on the record that I did show all the digital evidence that we have in our possession to Mr. Martin.
Okay, he's indicated on the record that he watched those videos.
Yes.
So, okay, call your first witness.
Thank you, Your Honor. The people call Lisa Martin.
All right, Miss Martin, come on up to the witness stand here. And Miss Martin, when you get up here, I need you to stand and face me, okay? Now, can you raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, if you can have a seat in the witness stand. Is Lisa Lisa?
Yes.
All right, you're a witness.
Thank you, Your Honor. Good afternoon, Miss Martin. I want to direct your attention back to the date of June 12, 2025. Do you remember that date?
Yes.
Okay, and on that date, were you at or near location 9?
Yes.
Is that in the city of Taylor, County of Wayne?
Yes.
And what's at that location?
My house.
Okay, and who lives at that location?
Well, it's my house. Both my brothers live there. I've
Who are
given
your
them an
brothers?
eviction notice.
Who are your brothers?
Eric Martin, and I have another younger brother, Kurt Martin. They
Okay.
both got served eviction notices. They're supposed to be on October 17th, and they ain't out.
Okay, and Your Honor, the witness did point to Mr. Martin seated at the defense table with the, let the record reflect that the witness has identified Mr. Martin.
Do you have any objections to the identity of you?
Well, just the same objection from the jump that I'm not the defendant, you know, named in the complaint. It has a similar name to me.
Okay. All right, it's admitted. The record shall so reflect.
Thank you, Your Honor. Okay, and on that date, June 12, 2025, did something happen that day that brings you into court?
Yes.
What happened that day that brings you into court?
I was sitting at the kitchen table on my phone. My brother came through the back door.
And when you say your brother, you mean Mr. Martin or?
Yes.
Mr. Eric Martin?
Yes.
Okay.
Came through the back door, walked past me, went over to my little radio that I listened to. If there was a volume level from 0 to 10, it was on 2. Okay, just goes up to it, turns it down. He does this like 10 times a day. Went, turned it down, walked in his bedroom. I walked down the hall, stood at his door, and I said, you know, you don't touch the radio. He goes, get out of my room. And he charges toward me and pushes me.
Where are you standing?
I'm standing right at the beginning of the bedroom.
Okay, like behind it, or are you in the bedroom?
No, I'm not in the bedroom. I'm standing right outside of it.
Okay, and Mr. Eric Martin is inside the bedroom and he charges at you?
Yes, yep, he's at the furthest part of his bedroom, so about 7 feet away from me. And he said, get out of my room. And then he comes toward me and shoves me, and knocks me off balance. I didn't fall. And then he pushed me again, but his hand like hit my neck right here. It was like a karate chop, but he didn't like try to karate chop.
All right, next question. You got to let her ask a question. She'll ask you, and then what happened? And then what happened?
Thank you. So you stated that you were knocked off your balance. How were you knocked off your balance?
When he shoved me.
And you're making this motion, did you use both hands?
And the record shall reflect, she's got both of her hands held up and pushing them away from her at shoulder height.
Thank you, Your Honor. Okay, and did you fall on the floor?
No.
Okay, and then you stated he tried to do that again?
Yeah, he tried to like push me again or something, but his hand like this, so I don't know if it slipped, but it hit me like right here, and it hurt for a little bit, but I didn't, I was fine.
A record shall reflect the witnesses pointing to her neck area.
Thank you, Your Honor.
And then that was that. And I told him, I said, you don't learn about putting your hands on me. That was the 16th time in 4.5 years that it's been my house that he's put his hands on me.
Did you allow that sort of touching, that being shoved and?
No,
All right, and just for the record, I'm not accepting the prior instances or allegations of prior instances, so that's stricken from the record.
Of course, Your Honor.
Go ahead.
Okay, and did you sustain any injuries at all?
Yes.
Okay, and what kind of injuries did you sustain?
A couple of days later, I noticed when I was getting dressed to go to the store that I had a bruise on my arm. So I took a picture of it, a couple of them, and then in a week or two later, it was still there, and I took pictures of that, yeah.
Okay.
And the bruise just went away 5 days ago, so it was there for 3 weeks.
And would you recognize those pictures if you saw them here today?
Yes, they're my pictures.
Okay. And Your Honor, may I approach the witness?
Yeah, are these proposed exhibits?
Yes, Your Honor.
What are they?
They
Proposed
are
1, 2, and 3?
proposed 1 and 2.
Proposed 1 and 2. Okay, you can approach the witness.
Thank you.
I'd like to get a copy of those too.
You have a copy of those, Mr. Martin.
Wait, on that paper, what do you mean?
I thought those copy photos were,
I don't, I can show you 10 pages, I got it on.
I was provided with copies. I left them in that room because half of the picture was chopped off.
okay, we'll get you a copy.
All right.
And then may I approach the
You
witness?
can approach.
Thank you. Starting with people's proposed exhibit number 1. Do you recognize what I'm showing you?
No, that's my arm.
Okay. And,
It looks like a foot, but it's my arm.
okay, and do you recall what day this picture was taken?
Yes, there's dates on the pictures. It was taken on the 16th.
Okay, and does this photo appear to be manipulated, changed, or
No,
altered in any
I
way?
don't know how to do any of that.
Okay, and Your Honor, moving to admit people's proposed exhibit number 1.
All right, does that accurately reflect the way your arm looked on that day?
Yes.
Any objections, Mr. Martin?
Yes, I object to the pictures being admitted based on the prosecutor told me, as I asked her, when was they taken? Prosecutor admitted it was taken 4 to 7 days later from the alleged, this allegedly happened.
All right, she
And based on the
allegedly,
timeliness of it, I moved to dismiss it.
All
from
right.
that. This violates my due process right.
We've got a tooken, y'all. Based on when they was tooken.
Fairness. which is
Okay.
timely.
Mr. Martin, the witness just testified that photo was taken on June 16th, which would be 2 days after the alleged incident. So that's her testimony.
They should have been taken immediately. And the
Do-
prosecutor, the disputes like this, what the prosecutor told me it was 4 days to 7 days later. She told me.
Okay, do you have any other objections to the photo being admitted?
Besides the timeliness, it's not a current, well, I mean, it's not true.
Okay, okay,
That's maybe
it's
my-
admitted. You can
For my argument.
ask questions about the photos, but the photo's admitted.
Thank you, Your Honor. And for the record, the date of incident was the 12th of June, and the photo was taken on the 16th, so it was 4 days after.
4 days after, okay.
Okay, and then do you recognize, I'm handing you Martez Peoples' proposed exhibit number 2 as well. Do you recognize this photo?
Yes, that's my bruise still a week or two later. It's still looking like that.
Okay, and you recall the date of this photo?
I think it was 23rd,
Okay,
22nd and 23rd.
and did you take this photo?
Yes.
And does it at all appear to be manipulated, altered, or
No.
changed?
No,
Is that-
no, I took the photo.
And is that the same as how it looked on that day
Yeah.
it was taken? And Your Honor, the people are moving to admit people's proposed exhibit number 2 as well.
All right. Do you have the same objection to the admission of this photo, Mr. Martin?
Yes.
All right, it's noted for the record. They're admitted over objection. 1 and
you,
2
Your
are
Honor.
admitted.
And Your Honor, may I publish the photos to the court as well?
You may.
Thank you.
Okay. Ma'am, can you tell me where on your arm is that injury at? If you could just point to your arm, where is that?
It was right here.
All right, so in between the elbow and the shoulder.
Yeah,
On
it looks
the
like a
interior.
foot because my arm fat's hanging, but that's exactly where it was. See how it hangs?
Okay,
It was right here.
all right.
And
Record
you
should
can see one
indicate,
of my spots in the picture too. That's where it was.
all right, record should
And it just went
indicate.
away.
Miss Martin, let me make the record here.
It's in the little flabby part that, when you're shaking your arm, it just jiggles like jello for hours and never stops.
Record should indicate that the photograph, the witness has indicated that that is her left arm in between her elbow and her shoulder blade on the lower portion of her arm.
Thank you, Your
Or
Honor.
interior portion of her arm, we'll say. Okay,
And then, Your Honor, this is people's exhibit number 2 from the 23rd.
okay, same area and location as the first
Right,
photo.
Yes, Your Honor.
It's still there.
And Ms. Martin, the photos that you were just shown, was that you stated that that was the left interior of your arm. Was that the same, was that the same area that you were shoved in earlier on that day? On the 12th?
Yeah, when I was shoved, like I said, it takes a while for a bruise to appear. It doesn't appear immediately.
Okay.
So when I noticed it, that's when I took the picture.
Okay, and what happened after this incident?
What happened
After you
after he pushed me?
Yes.
Well, after he pushed me, I said, boy, you got your nerve to put your hands on me again. You don't learn, do you? And I called the cops, and it took about 25 minutes for the cops to get there.
Did the police arrive?
Yeah, about 25 minutes later, and the whole time he's yelling at me from the bedroom, calling me names, laughing, thinking he's gonna get arrested, whatever. I ended up going on the porch because I didn't want to hear him, because that's all I hear every day, all day long.
Do you remember what he was saying?
Nothing I could say in here, just the
You
usual.
can say it in here. It's a court of law, ma'am. If you remember what he said, you have to say it.
Swearing, calling me names, you know,
What kind of names?
I'm lying when I never told a lie in my life,
And
but I lied.
what kind of names were you being?
I don't even remember. I'm so used to this every day in my home. I ended up going on the porch, waiting for the cops to come. They came, they asked me what happened. They went in the house. They called him out of the bedroom. He came down to the end of the hall. They asked him what happened.
And were you present when they were questioning him?
Yes, I was standing in the kitchen.
Okay, do you recall what he said?
Well, what happened was the cops asked him what happened. He said he turned down the radio because it was cat abuse. And then, he told the cops I was lying. And then when I heard that, that's when I opened my mouth. I said, I'm not lying. I don't lie. And they're like, okay, be quiet to me. And then they arrested him. And of course, as they arrested him, you know, what's your badge number? I'm gonna get you guys fired, the usual. They just laugh at him and laugh out, yeah.
All right.
And then, and that's it. And they took him.
All right, thank you, Ms. Martin. Nothing further for this.
All right, Mr. Martin, do you have any, let me ask you this first.
Examine her arm though too.
You want to what?
Examine her arm, make sure, you know, it's where they're at supposedly.
Well, they're not there anymore. She's shown us her arm in court. But I'll have her do it. Ma'am, can you just show your arm again? Where you had
Where
those-
it was?
Where the bruises.
What?
Don't talk to him.
I will
Wait,
stand up.
hey,
No, I was just saying, I'll stand
no,
up.
shh, quiet. Just listen. We're gonna get through this. Lift up your sleeve and show me. All right, see that, Mr. Martin?
Right here. There's
I'm
my
really
arm
careful
hanging.
here.
It was
I
right
really
here.
All right,
not-
thank you, ma'am. Listen, I'm gonna tell you two right now, we're not arguing back and forth. He has a right to ask you questions. Just do your best to answer his questions so we can,
Oh, I was just standing up. I wasn't arguing.
okay, I know, but I'm just, see, like, okay, go. Mr. Martin, what's your next question?
No, before I get to the question, I want to examine the arm closely.
You know, I'm not gonna allow you to, Miss Martin, stop. I'm not gonna allow you to go up to the witness and examine the arm closely. She's shown it. I'm the trier of fact. I've seen her arm. I've seen it. What's next?
For the record, I can't see from this distance, sir.
Okay, well, I'm not gonna allow you to approach the witness like
All
that.
right, well, anyway, now the videos, I want the court to review the videos. I don't want to get to that yet before, you know, after the question, whatever, but I want the videos reviewed in support of my arguments now, that the cops entered the house. That's actually only one video, so,
Are you moving for the admission of a video?
yeah. But
Is this a-
when they came in the house.
Is there a body worn camera video?
There is a body worn camera
That
on the
one.
interior of the house.
How lengthy is the video?
It's not that long.
Do you have any objections to the admission of that video?
I have no objection to it.
All right, this is stipulated exhibit 3. If you want to, you can put it on Zoom if you want, if you just wanna, if you're in the Zoom, you could just share screen. And then I can see it and the witness can see it and defendant can see it.
Your Honor, there are multiple videos, if I may ask which one he's referencing to.
I think it's the 5-minute one with the just entering the house. I think there's only one on that. The other ones are.
The
The
squad
car.
car?
Yeah.
Okay.
Can I say something?
No, she asked if she could say something. I told her no.
That's not from the night.
And she's correct, Your Honor, this is from the 16th. So this is not the video, the 5-minute one he was referencing.
Okay, that's when it violated the bond.
Mr. Martin, is this the video you're looking for?
Take a look.
Well, no, look on the TV screen. We made it real big so you could see it.
Okay, well, they're not in the house yet.
Well, they'll get there.
She likes it, and then she know what happened. I heard.
Your Honor, I believe this is the wrong video as well.
Yes.
But there's another one I do want to look at. Well, yeah, I still want to use that one too as support, but keep going just until my brother gets done saying something and original stuff. This is over to case to go ahead, keep going a little bit.
Okay,
This one's 31 minutes.
If we could skip ahead to the.
Yeah, you want to see what happens, what you want me to see what happened in the house. Is that correct, Mr.
Yes,
Martin?
I'm saying, but Ashley's playing. I just want to go further keep playing that one. You just play my brother. He makes a statement. I just want to go to there, then stop it and then go to that video. But I want to play that one.
Well, this is the one that's admitted. This is the one you wanted. So let's get through this and then you could try and move for the admission of another video. But let me see that. And just for the record, this is Exxon body cam 6/12/25. It looks like it's hours 22-27-44. So we'll start with this one. And if you want to fast forward it to.
And for the record, that's at 1:39.
Okay.
You turned up, it's way too low.
Can you make the audio any louder?
That's as loud as it's going.
There's no way to connect to the speakers in here, huh?
No, because of the feedback.
Oh,
Do you want me to just watch the videos?
Yeah, if you can do that, then yeah, I guess that would be better.
Can I see the computer so I can see the audio?
Yes, Your Honor.
Or so I can hear the audio?
It was how long, 31 minutes? But
thank you.
Watch these.
This is number 65 today. This answer since it's from my house of push me. That usually choked me a little. Was it nothing major? Like I'm not hurt or nothing.
You feel like you're gonna lose consciousness.
No, but I'm like, fucking touch me. Oh, I can lie and say, touch me. Yes, I'm fucking lie. I don't call the cops on you, Eric, unless you put your hands on me. Then, oh, shut up, that bitch. Shut up, that bitch. Big nose bitch. I'll do what I want. She went like this to me when he walked past it. And I said, oh, I said, I don't know where you got this.
Okay, so he pushed you.
Yeah, because he's also put his hand on my face before. Yes, my dad has never, 50 years of marriage, put his hands on my mother. Yeah, yeah, he's got a rap sheet and tail like this. You guys should know him. You know.
Eric, police. Eric, come out here. Come talk to us, Eric. Yeah, Jesus is alive. She's trying to just. All right, what's going on tonight, man? Well, I was turning the radio down, and the kitty girl, the cat always lays by the radio. I turn it down so she's not doing her cat abuse by turning the radio loud in the ear. She don't hear it.
It was like this. He always says this.
Okay. So I just turn it down so it's not blasting her, and she gets all emotional about it, tries to control everything. She lets her emotions go wild. It's usually. Just let him talk. You already talked.
My house.
Ma'am.
I know.
Outside. Outside.
No, I'm trying to get out of it all day.
I'm trying to hear this side of the story.
I'm just saying.
Ma'am.
He touches it 10 times a day.
Stop talking over us. Step outside so we can talk. No, I want you, but
yeah.
Trying to get your side of the story, ma'am. Anyway, so that's it. Turn the radio down. She goes wild and crazy, and that's it. Tells a lie about I assault her, and she's telling a lie. And I want to mention she tried to do this shit before. Total lie in court. It is on camera. The judge, prosecutor, for example, she's seen it me before, right?
Never.
What happened to her? And she lied. That was it.
Never
She
told a lie in my entire life. Okay.
You need to stop.
Just believe I've never told a lie ever.
You need to stop right now.
Well, you know,
She's
say I'm
crying
right.
out for emotions. All right, you're both concerned. I'm going to put it back. I told you she's right. You're going to arrest her for her lie. That's like your next week. You're going to get arrested for DV. You can't arrest someone for someone tells a lie. Tell me she lied. Stop talking. What is your name? Officer Buford. Okay, you're going to lose your job. Okay.
Yeah, everyone's gonna lose their job.
You have to arrest the rest of the people who don't have this. She don't have to. No, they don't have to. You're violating due process. She lied before, and it's on camera. The judge.
I've never lied a day in my life, so how would I lie? How do you don't get it?
Her building's already shot. It's in the court. She lied before. We're gonna take a walk through it. What's up? Yeah, it's right here.
Both my brothers are evicted. They should have been out of here 7 months ago. I shouldn't have to put up with this abuse.
He's going to jail tonight, ma'am.
I know he's going to jail, but I'm just, yes, I'm just sick of him saying, oh, she's lying. I have never told a lie in my entire life. But that's what they both say.
We're not pressing you about that.
I know that, but
What's your first name, ma'am?
Lisa.
She has forgotten about that time when she was 4 years old and she took the cookie from the cookie jar. And she blamed it on poor little Eric Martin. And she says she's never told a lie in her life, but I disagree. Eric got put in the corner that day in a timeout. All because of her.
What's your middle name?
K-K-Y.
What's your last name?
Martin M-A-R-T-I-N. Oh, there,
What's your date of birth?
Job.
Ma'am.
11/22/69. Oh, he showed up 1,000 lawsuits.
What's a good phone number for you?
734-512-608.
I'm just skipping that ahead.
Yeah,
Just
that's
second.
that's the part. Okay, that's further up as I was relevant.
He does that, he unplugs my plug line 10 times a day.
That's all you wanted me to hear on that? Okay.
May I approach on?
You may. Thank you.
And I,
All right, hold on.
okay.
Hold on. Mr. Martin, you're cross-examining the witness. So, okay, now you've had me see the video. Do you have any questions for the witness?
Yes, but I just want to point out in case, want me to do it.
Well,
before.
that's safe
That's
for
my-
argument. Mr. Martin, you get to make your legal arguments or your factual arguments at the end of the case. We're in cross-examination. So I've watched the video. It's been admitted. Do you have any questions for the witness?
Yes, I do. I'm just saying I want some more motions to make that remember
Okay.
to dismiss.
No, go. Ask her questions.
All right.
Stay right here.
No, Mr. Martin, stay there, but you can ask questions. There's a microphone right there.
I was one of the podium. That's not usual procedure. All right, you made a statement before, true, that I don't know the law. True or false?
True.
Based on what?
You don't know the law. All you do is break the law for 40 years.
So what is that statement based on then?
I don't think it's relevant.
It's irrelevant. Next question.
You said, the house is yours. You said that several times.
Yes, it is mine,
Your
But
Honor,
as
I
you-
object to
but it's not in my
relevance.
name. It is mine. I have to go to prove it.
And I've taken judicial notice that the house in the city of Taylor is under your father's name. Both parties agree to that. So next question.
Okay. You made the statement that I've been evicted, true or false?
Yes, you
Your
got
Honor,
served.
again, relevance.
How's that relevant, Mr. Martin?
Attack or credibility?
All right, go ahead.
And, well, has any, formal proceedings been filed in court ordered by a judge that?
Well, those are two different questions. So wait, if he's gonna try and attack her credibility, the first question was, you asked you asked her what, if she had ever evicted you, right? So let's, wait, let her answer that question, yes or no?
Yes, he was served an eviction from here, you know, you get the paper. He was
Okay.
served it September 17th.
All right,
He was supposed
one
to be
sec.
out October
Oh, next question.
Has the judge ordered me evicted, yes or no?
No, you did not get out October 17th and you haven't left.
Have you filed official paperwork in any courthouse or this courthouse?
Judge, I don't see the relevance.
Let me just, I'm giving him some leeway. He's in pro per. I don't know where he's going with it, so I'm gonna allow it. Go on, Mr. Martin.
Have you filed any paperwork in court that actually got me, or that caused me to be evicted, yes or no?
Yes, I went to the court window when you walk in and go to the right and got the paper for the eviction, filled it out, handed you the copy. I have the other copy. You were supposed to have been out October 17th.
So did you initially officially file it with the court clerk, yes or no?
Yes, I got the paper from the court clerk.
And do you have any proof of that, like spam?
You have the copy, I have the original.
That's not the same thing. Just because you picked up the paperwork from the court clerk and you filled it out and handed it to him, that doesn't mean you filed it with the courts.
But no, okay, well, anyway, so no judge issued an order, you said again, right? No judge issued an order,
No, I did not see a judge.
okay? I didn't ask, did you see one? Did one issue an?
Well, it sounds like maybe she filed a 30-day notice to quit and gave you notice, but then an eviction case was not brought because you never saw a judge. Does that sound about right? Okay, next question. I got it.
Is it true you said in the videos several times you never told a lie in your life?
That's right.
Now you say I pushed you. How many times did I push you?
You already heard that.
Answer the question, ma'am. No
Twice.
argument.
And where in the body was that supposedly?
Obviously on my arms, since I have a big bruise for 3 weeks. And then the second time, like I said.
Well, the picture's not clear.
I know.
I see the point in this area around the left shoulder. The other picture's unclear. Where on the
Judge,
body
I
that's supposed to
object
be?
and ask that defense formulate his statement in a question.
Yeah, you have to ask questions. You can't just
I did.
make, you're testifying.
Where is it on the body? Where is it on the body? Besides the other one that was by the left shoulder, I'm asking her, where is the other supposed bruise? What do you call it?
There was only the one.
So now there's one.
All the pictures are of the same bruise.
Okay, I understand. Next question.
Is
Mr.
it-
Martin, she testified that one of the bruises, the first picture was taken on the 16th of that area on her arm. And then she testified the second photo was the exact same area on the 23rd where the bruises were still there. That was what she testified to.
Yes.
Okay, isn't it true that you, have been bit by some type of bug causing these?
This overruled. Go ahead.
Hurt my gosh, I don't know.
No, she's got a right to do that. She's a prosecutor. She's objecting to irrelevant questions or questions she believes are irrelevant, that she's doing her job. But I'm giving you leeway to see where you're going.
I think they're a little too quick because I didn't hear me out.
Okay, go on, Mr. Martin.
But isn't it true that you've been bit by a bug before, causing you to have a skin condition in your
Yes.
arms?
scarred, yeah, my arms are scarred. And bottom of my legs. What is that guy with it?
Feel like get to that in argument, but, okay, that's the question. Thinking other questions. Okay, so is it true that, I turn the radio down? I guess you admit that, I guess I don't need you to, you already admitted you turn the radio down. Isn't it true that, Kitty Girl the cat was laying by the radio when I turned it down?
I don't remember where she was at. It's none of your business to touch my radio. If it was on full blast, it's none of your business to touch it in my house.
Just answer the question. Do you remember the cat being by the radio, yes or no?
No, I don't
All
remember.
right,
the
next
cat.
question. She doesn't remember. Next question.
It was on volume 2.
No more. Next question. It's
Okay.
irrelevant. I quite frankly,
I
whether or
know.
not the cat was by the radio means nothing to me as a trier of fact.
Oh,
Next question.
He knows the law.
I'll
I
get
know,
to that, how it is,
but
though.
you don't know how to be quiet and answer questions.
I'm answering them.
Ma'am, do not respond to me again. If I ask you to answer the question and then quit talking, just quit talking. Next question.
Do you have a receipt for the radio since you allege it's your radio?
Irrelevant. Next question.
I object to you saying it's relevant because.
I don't care. I'm the judge and I said it's irrelevant. Next question.
Is it true that a case was dismissed before where you testified that you never swung it?
That you never what? I just
I'm
didn't
asking
hear
her-
you. I
I'm
just,
asking her, has a case been dismissed before with me that you tried to bring against me alleging I attacked you? And I asked you, did you swing me before? And you said no. But the judge has seen on the video that wasn't true.
Judge, I'd object to relevance on this as well.
Oh, I can explain that.
all right, well, I don't know if it's relevant or not.
It's not.
I mean, does it go to her credibility? Maybe. So I'm gonna, go ahead, explain it.
I've never swung at him, for one. This video he's talking about, the first time that he didn't put his hands on me, he kicked me in the stomach back. And I called the cops. We had a Zoom meeting with Slavin on that. I couldn't do Zoom at that time on my phone. My boss let me do Zoom on hers while I was at work. I went in the conference room. I let them know that this phone's gonna die any minute. They said, if it does, call this number back. So as he was representing himself again, asked me a question, something, the phone died. I called the number right back and they said, the judge dismissed it. I said, how? He kicked me in my stomach for no reason.
Okay.
And they said he showed a video to the judge. Well, there's no video of me ever coming at him. So what he showed, he basically committed perjury. He showed a video of years ago when he grabbed my wrist so hard and I had to fling my arm like loose. That would be the only video that he could have shown Judge Slavin
All right.
for him to dismiss it.
Okay.
That had nothing to do with him kicking me in my stomach of what the incident was about.
All right. Mr. Martin, next question.
Is it true that after I turned the radio down, that you went to my room getting in my face?
No, I didn't even walk in the room.
Wait. Okay, that was her answer. Now, what was your next question?
Did you go to my room after that? Told me he was gonna go to my room, invest with something in my room after I turned the radio down. Did you do that?
I didn't even go in your room, which is really my room, because it's my house, but no, I was on the outside. You said, get out of my room, charge toward me, and that's when you pushed me.
No more questions that I can think of right now.
All right, any redirect?
Just one question. Ms. Martin, could you have gotten that bruise any other way?
No,
Okay, you
I
wouldn't
never
have
left the
house or
house,
anything?
never left the house, didn't even vacuum out, I think for a couple days, no.
Okay, nothing further.
Okay, so witness, do you have
Excuse me, yeah, just
recross?
some more,
Okay.
more questions, just.
Go ahead.
Sorry, but, isn't it true that you smoke cigarettes every day?
Objection relevance, Your Honor.
How's it relevant?
as to, so be my argument, how she's partially suicidal by smoking cigarettes, and this is why
Okay.
she should be willing to
No.
work herself up.
No. Sustained. Next.
So the next question will be along the same lines of that. If you're not gonna allow that, then the others do the same thing, so that's all I can think of right now.
All right, can this witness be excused? Do we have any further questions for this witness?
No, Your Honor.
No questions.
Okay, ma'am, you're excused. Thank you.
And the people rest, Your Honor.
All right. To prove this case beyond a reasonable doubt rests solely on the prosecutor. Do you understand that?
Comprehend that.
Okay, and you understand that I could not use your silence against you in making a decision on this case. Do you understand that?
Yes.
So that doesn't matter one way or another to me. I would not consider whether or not you testified or whether you didn't testify when making it a determination in this case. Do you understand that?
Well, I don't understand. I don't have it. Well, I can comprehend. I don't have to, but I don't know. I don't agree. Maybe the legal aspect, whether it's.
Well, you don't have to agree with it. I'm telling you, as a judge, I just need to make sure you understand that I'm telling you, your refusal to testify would not be used against you. I would not consider it. Do you understand that?
I comprehend that. Yeah.
Okay. And are you waiving that right to remain silent and testifying in this case?
Yes.
Okay, before we take your testimony, do you have a motion for directed verdict or a motion otherwise?
Yes, but you know, there's an issue of kind of evidence I want to get to kind of support the case too. And being in jail, I don't have access to it, and now the lawyer's not doing his job, so now.
Mr. Martin, you had a bond condition. I want to be clear on this. You had one bond condition that you would not follow. I told you you could not return to that residence while the case was pending. And you continued to go back to that residence. And you violated the conditions of this court. And that is why you were in custody. So let's be crystal clear. The reason you have personal bond. I let you out. And you refused to comply with the conditions of my bond.
I had nowhere else to go to either.
Well, that's not a me problem, sir. I'm telling you, the reason you were in custody, solely the reason you were in custody is because you would not follow my bond conditions. So you took away your freedom because all you had to do was that one thing and you couldn't do it. So let's be crystal clear on that. Now, did you have a motion?
Yes, I have some, yes.
Your record.
Move to dismiss based on, well, the police officers due forward is not here, and the other one, I move to dismiss on that. My right to cross-examine is violated on that because they're not here, so. Twerk, Dylan, and Jeremy Duford, they're not here, so.
Okay. Anything else? The prosecutor has a right to prove her case as she sees fit. And if she wants to bring in a complaining witness and prove that through the testimony of one witness, she's entitled under Michigan law to do so, or any law in the country. So that motion's denied. What else?
Well, I have a response to that. It's true as her right might be, but I'm saying my right to process is being violated. So it's irrelevant to my right to be violated.
Okay.
Cross-examine.
You made your record. What's next?
Next one is, under, I move to dismiss under MCL, it's the 28.6B. I'm gonna pull it up on you can refresh your memory.
Thank you. Thank you. I will do that. Go ahead.
It's like section 1. If I remember right, I think go to section 1. I was just looking the other day on the tab of the jail, and I had to hurry up and turn it in, so I have a chance to write it down. I'm pretty sure it's section 1. At first, the police is their limitation on arresting, and it mentions, I'm pretty sure it's section 1, where it says they shall not arrest basically unless if they're not aware of a crime being committed right in front of them, they're not supposed to be arrested.
Okay.
So they shouldn't have arrested under that statute, and therefore, since they shouldn't have, Now, well, let me ask you before I get to the rest of my argument, do you see where it says that in section 1? Or 2? It's not much reading, it's right under the, you only have to read all the heading and all that, just right when it gets to the text of the statute. It's referring to police as, like I said, the limits on arresting. They may arrest only in felony cases or if a crime has been committed in their presence. It means they know for sure. Otherwise, they shall not arrest. This statute supports that. They did it anyways, so therefore I've been illegally arrested.
Okay, I see the statute, I've looked at the statute, and that motion's denied.
I'd like to know the reason.
Okay, Mr. Martin, well, you can appeal me.
I will, and actually, I want to get an appeal form for the request.
Okay, well, you gotta find out what my ruling on the case is before you do that, but any motions or that you've made that I've ruled against you on, will, you potentially can file your motion on those, and we'll make sure we address that, but I'm still taking evidence.
Don't be a big meanie, Judge.
All right.
Anything else?
I don't think so. No.
All right, Mr. Martin, you want to come and take the witness stand? Stand and face me, Mr. Martin. And raise your right hand. You understand you have a right to... Sir, you swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, have a seat, Mr. Martin. And he does not have an attorney, so I'm going to allow him to just give a narrative, and then you can cross-examine on that narrative. All right, Mr. Martin, go ahead. What do you want the court to know?
Start off, my sister is she's a constant liar.
Okay.
She's very aggressive,
Okay.
psychotic, and to a degree.
All right. Is there anything you want to tell me about this instance?
Well, first we'll start with the general, and then we'll go to specifics.
All right. Well, that's character evidence, and it's not admissible, so it's stricken. Go ahead.
And I object to that because it's relevant to the credibility.
Okay, it's not. You're talking about her aggressive behavior, right?
Excuse me?
You're telling me she's psychotic and very aggressive, and that really doesn't go to her credibility. That goes to...
Well, yeah, let me argue in to see it.
All right, what's
Well,
next? What else do you want to tell me?
That's reconsider after I do my argument.
Okay,
I'll point out it's relevant.
all right.
I wouldn't say things that's not relevant. So even though I'm not an official attorney, I don't have their official training. Studying and practicing law for 30 years, I know it's relevant.
Okay, all right, go ahead.
So basically, on the day in question here, was relevant to the complaint. Turned the radio down because she had it too loud. The kitty cat was laying right there by the radio. She had it at an uncomfortable level. Turned it up, it was too loud. I turned it down in consideration of the cat. So not stressing the cat. And it wasn't no volume, like low, real low, or too, like she says. It was loud and at a comfortable level. So I do it. She gets all crazy and emotional. You're not gonna be turning my radio down. Turn it back up. I'll go in your room, mess with it. So I went back in my room. As she said, she was going to my room, mess with some. So I went in my room before.
Wait, what? Who went to the room first?
I went to the room first.
Okay, and then what?
I mean, as she said it, so she already gave me indication, going in the room, mess with something in my room. So I went in there so I could see, so she ain't doing something I can't see. But so then she followed me in there, like right at the doorway. She came in behind me. And then she's standing right there at the doorway, and then still shouting, you're gonna be turning my radio down. Whatever, this is my house, and just getting all emotional and crazy. But that's it basically. And I just turned around and said, get out of my way. She was just blocking my way, but she was all in my face, and trying to instigate me to do something to her, as she normally does, as she did in the last case, which is why they dismissed. They seen on the videos.
All right, I don't care about that case. Keep going.
Basically just getting aggressive in my face, and I told her to get out of my way. She wasn't moving, trying to instigate me to assault her. But I didn't do that. I just I had a little leeway like between the wall and where she was standing. She was standing to the left a little bit, so I just turned my body like this, and since she wouldn't move, I just went beside her. I didn't push her, do nothing. I went alongside her, behind her, and went to the refrigerator, and that's basically it.
Go out in the hallway. Go in the hallway. Yes, you, go in the hallway.
Yeah.
Go on.
I've listened to all this lies.
All right, go on, Mr. Martin.
That's basically it. I went to the refrigerator, and that was basically it. And then I went to my room, and she called the cops, and that's it. That's pretty much it. And, like I said, basically she lied and didn't do it. They
Anything
grabbed
else?
her, nothing.
All right, so your testimony is you didn't push her, you just walked beside her?
Yeah, slip like turn my body like this, but I mean the way she instigates someone, she instigates people to do stuff like that, and then she wants to act like she's the victim, but that's not true. And as her own testimony, I want to say admits.
Just,
Yeah, maybe
it's
that's-
not argument, just tell me what else happened or whatever. All I want to know about is what happened that night.
Yeah, that's all I have to say that happened that night.
All right, cross.
Thank you, Your Honor. And Mr. Martin, to start, you do understand that you're under oath and under the penalty of perjury, correct?
Comprehend that?
Okay, and yes or no answers if you could.
Yes.
Okay, and you and Lisa Martin are siblings, correct?
What's the word sibling?
Brother, sister.
Yeah.
Okay, and were you both, on the date of June 12th, 2025, you were both at the location 9074 Clipper in the city of Taylor, County of Wayne?
Yeah.
And that's your home?
My home now, well, it's our father's, it was our parents' house.
Do you live there?
I live there, I've been living there all my life.
And does Lisa live there?
Yes.
Okay, and on that day, June 12th, did you and Lisa have a verbal disagreement?
Verbal back and forth, yes.
Okay, and was it about a radio?
Yeah.
Okay, and would you agree that that argument got heated? Were you upset?
Stuff, I mean, back and forth, I'm not sure about the set part, but verbal back and forth, maybe a little bit, but nothing to the degree gonna make me salt her. I know that's what she wants. I know she's gonna call the cops anyway, so I know there's no sense in
Okay,
doing that.
and so you're stating no, that it wasn't heated?
I guess every argument maybe to agree might be slightly, but I'm not gonna say it was really heated, I mean, no, I mean, maybe a little bit, but not really, no.
Okay, and was your tone, was it raised?
It was maybe slightly, not too much really, but.
Okay, and you're denying that any physical contact occurred with you and Lisa Martin?
No.
Okay, and you're stating at that time that you were inside your bedroom
Yes.
and Lisa was by the doorway?
Doorway like in my room, just barely though, but just like 1 foot inside the doorway. And I walked away a little bit and I just turned right around.
And do you know how big that doorway is? Is it wide? Is it narrow?
I'm not.
Is it a regular house doorway, Mr.
Yeah,
Martin?
it's regular.
For a bedroom? I
Ain't no
saw the
mansions.
pictures of the door and the,
This ain't no mansion, so, but she was standing to the left, right, just had enough to get by her. Plus, I'm a small guy, I can, stand to the side and I can get by, you see, I'm a pretty skinny guy. I mean, only 140 some pounds, I'm telling you, which for me to get through.
Okay, and Mr. Martin, you're stating that you never touched her at any point?
No.
You never, even walking past the doorway, didn't accidentally hit her or anything?
No, even though she wanted that to happen, was standing in the way, but I had enough way to get through and, no.
Okay, and you heard Miss Lisa Martin testify. Do you disagree that this incident took place?
Her testimony is a lie. The only thing she told the truth was about the radio. I turned the radio down.
But you're disagreeing with what she testified to today, that an assault occurred?
Yes,
Okay, and you're maintaining that today?
yes, and I don't agree that, I'm also testifying that these supposed They look like blotches on the skin. That ain't caused by no finger pressure. That's
But you're maintaining that today, right? That didn't occur?
right, yes.
Okay, and one moment, Your Honor. Mr. Martin, at any point in your life, have you ever been convicted of a crime of dishonesty?
Fraudulently assumed, so yes.
Okay.
Was that within the last 10 years?
No.
No, Your Honor. Okay. I have nothing further from Mr. Martin.
I have some more things to say.
All right, well, if there was a crime of fraudulent activity and he did testify at some point that there was some crime of dishonesty in his past, it's past 10 years according to both the prosecutor and the witness, so I'm not using any of that testimony and making my decision. Mr. Martin, go ahead.
Yes, also want to say now, the main reason why my sister, keeps up with this agenda of telling constant lies against me, trying to get me with these domestic cases, is because she has this agenda trying to take over the house for herself, hoping the cop would be dumb enough to arrest me like they was. No problem cause, no evidence, just based on her word. And this is the agenda why she's doing it. And then she even had her daughter try this on me too, which that case was dismissed too. This is why there's no evidence. And she knew, and I reminded her of it, by the law, you gotta have evidence, you gotta have not just your word, it's not evidence.
Well, your testimony is evidence, Mr. Martin, so.
Well, I said, but
And that is, the jury instructions tell me that I can convict based on the testimony of one witness, so I'll follow the jury instructions. But go on.
no, but that's no more than my testimony either.
That's correct, sir. You're absolutely right about that.
So, but yeah, so her daughter had tried the same thing, that case was dismissed, so they both try to conspire with each other.
All right, I'm striking all of that. None of that's relevant. What else, Mr. Martin?
I'm just gonna say that's their agenda, that's
Okay, I understand
That's my
that.
sister's agenda.
All right, Mr. Martin, anything else? All right, are you done?
Yes, Your Honor.
All right, Mr. Martin, you can have a seat. You have anything else you want me to consider?
No, that's what I'm trying to think, I don't wanna rush and then forget something else, I'm trying to.
Well, that's all right, Mr.
Right.
Martin. I think you covered quite a bit here. So you can have a seat back at the stand or at the defense table. All right. And Mr. Martin, are you resting at this time?
Resting? What does that mean?
Well, do you have any more witnesses that you're calling?
Oh. Okay. Well, no, I wanted it first, but no, since you questioned her on it, it's not necessary. I was gonna, like I said, the tax assessor, but that's good. I'm glad you covered that. I don't need that now, but let me think.
Mr. Martin, you don't
Oh,
have.
the other video. That's right. It's just reminding me.
All right, Mr. Martin, you can have a seat. Just have a seat. I'll accept that other video, but your brother's not here to testify about that, okay? And I don't really think it's relevant. Do you have a closing argument?
Yes, Your Honor. Start, Your Honor. Today we're here for assault and battery charge, domestic violence count against Mr. Eric Martin. We as the people believe that we have met the burden beyond a reasonable doubt for these charges here today. We did hear testimony from Miss Lisa Martin. This is Mr. Eric Martin's sister. They both reside in the same home. That a dispute occurred over a radio on the date of June 12th, 2025 in the city of Taylor, County of Wayne, location being 9074 Clifford. This is both these individuals' home. Miss Lisa Martin testified at some point this after a radio was turned down, she approached Mr. Eric Martin's room. Eric Martin he stated to get out of her room. He shoved her once and then attempted to shove her again, but hit her neck the second time. This was unwanted contact by Mr. Eric Martin against Lisa Martin. The testimony believe our witness, Miss Lisa Martin, to be credible. At no point did she change her testimony or change the story. So we believe that we have met our burden today and ask that you find the defendant, Mr. Eric Martin, guilty.
All right, thank you. Mr. Martin, closing arguments.
First of all, the witness is nowhere near credible. They have no credibility at all. As it was evident today by reviewing the video, that my sister made comments several times, "It's my house, it's my house." But yet, as she admitted to the judge, the house is not in her name. So it's not her house. That's one lie right there. Because she's a liar. And her other statement was in the video. I don't know the law. And as she admitted it today in court too, I don't know the law. That's totally baseless.
All right, well, Mr. Martin, she's not charged and you're not charged with not knowing or not knowing the law. This is a domestic violence case.
I realize I'm saying as to her credibility, this is a lot.
Okay, well, Mr. Martin, you didn't go to law school. I don't care if you're personally insulted by your sister saying you don't know the law.
No, I'm not. I'm saying this goes to her credibility.
Okay, well, it doesn't. It doesn't. Because you don't know the law.
Obviously, I made reference to NCRs in here, how my
Okay.
city chart.
Anything else, Mr. Martin? Are you ready for my ruling, Mr. Martin? Because I'm ready to rule.
No. Like I said, I got more lies to point out.
Oh, okay, well, you don't even have to. I'm gonna make my ruling, all right? The prosecutor has the burden of proving this case beyond a reasonable doubt. It's the highest standard in criminal law. It's like 96%. The jury instructions tell me I can convict based on the testimony of one witness. Jury instruction addresses that, but I also have to consider jury instruction 3.6 on witness credibility. And there are factors I'm to look at when I determine whether or not I believe a witness is credible. And those factors do not weigh in Miss Martin's favor. There's no doubt she had a memory. She was consistent with her story to some degree, but she evaded questions. She argued with this court. She argued with the prosecutor. She argued with Mr. Martin. I had to tell her on multiple occasions to be quiet. Ultimately, I had to remove her from the court for her behavior. She has no self-control. That was abundantly clear to me. Mr. Martin has appeared in front of me many, many times at this point, and he's a handful and he's frequently disruptive during court proceedings. That doesn't mean that I'm going to take all of that into consideration when I'm determining whether or not someone is guilty of the charge of domestic violence beyond a reasonable doubt. There's no doubt in my mind that people have personal interests involved in this case. And here's the reality. It's very difficult to prove a case based on the testimony of one witness, especially when that witness is argumentative to the extent that she has to be removed from the courtroom. That's just the reality of the situation here. And Mr. Martin, whether or not I agree with him 99.9% of the time, is not what the issue is here. The issue is whether or not the people have met their burden of proving Mr. Martin committed a domestic assault beyond a reasonable doubt. And based on the jury instructions, based on the testimony that I've heard today, I do not believe the people have met their burden. And the case against Mr. Martin is, my verdict is not guilty. Anything else?
Thank you for your just decision.
Well, Mr. Martin, that doesn't mean I think I agree with you on most things, but you don't have the burden today. And that's my ruling. We're all set.
Thank you.
Thank you.
And now the judge needs to go get that box of wine out from under her desk, or the whiskey from the drawer. Oh my goodness, thank you so much, Squishy, for sharing that with all of us. I loved it. I loved it. Oh yeah, no kidding. She would need to after a day with Eric Martin. Yeah, totally necessary. Yeah. Okay, guys, I need to go because I gotta go potty. I'm so sorry. I just had to make it through the case. Thank you guys so much for another amazing night. Every night with you guys is great. Be safe, be well, sleep sweet, and much love.